So then we get to the interrogatories. Now, these are, you only get 50 of them. And so you want to word the questions very carefully, right? Like you want to word them very intentionally and all of that stuff. What is this?
What is the difference between Anne Frank and Santa? The direction they go in the chimney. Now that I've offended the Jews, who has a smaller micropene? Kurt or Monty?
I don't know. I just got it. Shit, fucking. I can't answer that question correctly. It can't be done. You've created a paradox. I need a quantum processor for this. All right. So you only get a limited number of these questions. And so they're worded, very carefully. And again, I cannot speculate on why he did not answer these questions, but he did not answer any of them. The moment we sent them over, they sent back the withdraw and run away request. So interrogatory number 1, identify in detail and describe all factual bases that you believe support or refute any inference that you may have engaged in inappropriate conduct with minors, including any facts, behaviors, or omissions you are aware of that may contribute to such an inference. That's a bitch of a question, isn't it? That's a bitch of a question. So explain the ways in which you're a fucking creep. Oh, okay. Got it. Interrogatory number 2, identify any statements made by you, including but not limited to social media posts, videos, photographs, or other materials that could be interpreted by a reasonable person as suggesting or implying that you engaged in inappropriate conduct with minors. So what I need you to do is go through anything you've said, and things that other people may have said about you. And you need to find out and identify and tell us what would suggest or imply that you were inappropriate with a minor. Like that's, again, it's one of those questions that, for me, it's pretty simple to answer that question. Not a goddamn thing. Next. But for other people, it's not that easy to answer that, Interrogatory 3, state with specificity whether any other person has accused, called, or labeled you a pedophile, child molester, or similar term. And if so, identify the date, the person making the accusation, the circumstances, and any documents evidencing or relating to such accusation. Now, I can't speculate on what he would answer here. But this is an interesting question just based on the known public facts of the case. And one of those public facts is that I was introduced to Montegraph on a stream by Medicare, in which Montegraph was losing a lawsuit because a guy, I believe his name was Drummer 88 or something, called Montegraph some brand of pedophile or child molester. And Montegraph lost his defamation lawsuit against that guy. And so that was, Jim and I did a stream, and we went through the filings and we went through the case. And it was funny. Like, it's a funny stream, if I remember right. Jim was on there, so at least half of it was funny. And so, there's at least one instance where someone has done this and it resulted in a lawsuit, and that lawsuit was part of the conversation. So one would assume that would be part of the answer. Now, this is publicly known, this is not new material, right? So, but that's still an uncomfortable question to answer when the answer is anything other than nothing. Interrogatory number 4. And if you're on the internet in 2025, you've probably been accused at some point. So, depending on the size of the accusation, in this case, that resulted in a lawsuit, there's a record of it, and there's a record of you knowing about it. So that makes it that makes it uncomfortable, because some things, people might go, oh, I didn't see that, right? Like lots of stuff gets said on the internet that you'll never see, right? It may even be about you. You'd never know. Interrogatory number 4 says, identify and describe in detail all emotional distress, mental anguish, or psychological harm that you claim to have suffered as a result of defendant's conduct alleged in the amended complaint. And this is a good question. This is, he alleged all of this stuff. So talk about it because it's not in the complaint. Identify and describe in detail all documents, bills, or records that relate to or evidence the damages you claim to have suffered as a result of emotional distress or psychological harm caused by defendant's conduct alleged in the amended complaint. One of the things that was always lacking in this case was a claim of damages. They generally alleged that there were damages. They never came out with even an estimate of what the damages would be. And, that was really going to be a big problem for their case. Now, they did, I believe, they claimed that some of the defamatory statements were per se defamation. That means that they get to presume that there are damages and they don't have to identify them with specificity to fulfill the element. But to make a recovery, they would have to at that point. They would have to lay out how they were harmed, but it just gets them past the damages element. So on some of the statements, they could have, gotten past that one element. Remember, there's 5 elements of defamation. So that one element of the claim, they could kind of breeze through. But when it got down to if they won and there was a verdict and an award, then that award would be determined not by the rules of per se defamation. They would have to actually prove out their damages. Number 6, identify each and every healthcare provider, therapist, or counselor from whom you have sought or received treatment for emotional distress, mental anguish, or psychological harm allegedly caused by defendant's conduct alleged in the amended complaint, including the dates of treatment, the nature of the treatment, and the costs incurred. When you make a claim of emotional distress, you can't just say, well, I'm emotionally distressed. You have to show it. And by showing it, you typically have to seek treatment of some sort under Minnesota law. And so it's like, okay, well, now you have to show us that there is, a record of this mental health issue, because mental health issues are not obvious. I mean, well, sometimes they are, but emotional distress isn't obvious to the outside world. So you have to go in and, you start getting treated for it. And then an expert can talk about what type of treatment you may need, the duration, the intensity, the frequency, all of that stuff. And so then that helps you develop a damages number. If you're not going to any of those things, if you're just claiming emotional distress and not going to them, this question would be very difficult to answer. I don't know. We'll never know if Montegraph was actually seeking treatment, for the injury he said he suffered. I have no idea. Number 7, identify all persons who have knowledge of your emotional or psychological condition allegedly caused by defendant's conduct alleged in the amended complaint, including family members, friends, coworkers, or medical professionals. For each identified individual, this is how you gather witnesses, right? Provide contact information for that individual, including the person's name, email address, home or business address, and telephone number. So you get this information. You would then use that information to work on your deposition list or your witness list, or get witness statements, anything about it. See if the person actually agrees. See if they have witnessed that and say, yes, I agree. Number 8. Identify all persons or entities who ceased doing business with you or withdrew business opportunities because of defendant's conduct alleged in the amended complaint. For each identified individual or entity, provide contact information for that individual. So again, another one's okay, well, you say they interfered with your business. How? Show me the person who can verify. Yeah, I pulled away because I heard that guy was whatever. If you don't have people like that, then you're going to have trouble proving damages. And, part of the interrogatories is you want to gather their evidence also. You want to figure out what it is, because you want to go talk to these people. Number 9, Describe in detail all reputational harm you claim to have suffered as a result of defendant's conduct alleged in the amended complaint, including any specific lost business opportunities, job offers, clients, employment, or income. I think Monty would have had a big problem with this because, as I stated, his reputation was not great prior to this. And you can say that I damaged your reputation all day, but you got to put up at some point and say, no, here's where that happened. One of the things that's interesting, for example, Aaron Imholt and Patrick Melton. Aaron has been calling Patrick Melton a pedophile for over a year now, I believe. I believe it's over a year. Don't nail me on the timeline. We'll just say roughly a year. And when we went to Stoney's bar, for example, the owner said that Aaron says you're a pedophile to Melton. Says it right to his face, and he says, I don't want to sell you a hat because I don't want to sell a hat to a pedophile. So now you know and can demonstrate that reputational harm has occurred, and that would be critical in a defamation case against this. And so the thing that Monty would have had to do is to produce something like that. The weird thing is, it still doesn't happen very often that someone says that. If they want to disassociate, they just do, right? So number 10, state the total dollar amount or value of income, revenue, or business opportunities you claim to have lost. This is, again, going to damages, which I think was going to be a problem for Monty, was to show damages. It's not for any reason, not for any nefarious reason other than it's really hard because how do you know what actually caused it, especially in the realm of social media? It's one thing if you get fired and your boss is like, hey, yeah, we heard online that you're, a child, whatever. It's like, okay, well, that's an obvious thing. But when you do this, it's like, okay, well, maybe you lost 400 viewers, but you don't know if it's from that or something else. You can have a guess. You don't have a fucking exit survey. Describe in detail all the steps you have taken to mitigate the harm you claim to have suffered. I don't know on defamation specifically in Minnesota. I haven't checked, but some torts have a duty to mitigate where you have to try your best to mitigate any harm. And if you don't take reasonable efforts to mitigate the harm, the court can determine that, they can reduce the award that you would have gotten. So you should have mitigated it. And had you tried to mitigate it, the court estimates it would have been this much, et cetera. So that's why you would ask a question like that. What have you done to mitigate the harm? In some cases, if you don't mitigate the harm, the case can be dismissed out. Number 12, provide a detailed description of your professional activities as an entertainer, artist, and video producer, including the nature of your work, the platforms used for distribution, and your sources of income from January 1, 2020 to the present. So getting back into, you're gonna say that all this harm happened. Well, first show us what there is to harm. Good question. Number 13, state whether you have ever been investigated, charged, or convicted of any crimes, including but not limited to pedophilia or other crimes of moral turpitude, and provide details of any such investigations or proceedings. And this is a bold one here. Investigated, charged, or convicted. So not just found guilty, but has it ever happened? And part of the reason for this is that, some people, when they get accused of something, even if they're not convicted, people are able to reasonably determine that they believe that the person did the thing, even if they're not legally found guilty. And so they can have that belief or not. So you want to know about any of the accusations that may have been out there, that made it to that stage. Number 14, describe any public statements, posts, or communications you have made about defendant Nicholas Rekieta or Rekieta Law from January 1st, 2022 to the present, including but not limited to social media posts, videos, or comments on live streams. So this is an interesting one. Montegraph has privated several videos in which he talked specifically about me and other people, like that umbrella guy, for example. He's privated those videos, but you have to describe them and you have to do so accurately. And if there's something that the opposing party knows about that you try to obscure from them, that can be a big problem. that's a discovery violation. So you're supposed to be very candid about answering this question. Number 15, identify all witnesses you intend to call at trial to support your claims and provide a summary of the testimony you expect each witness to provide. This one is one that you ask, but you're going to get an incomplete answer at this point. Like, trial wasn't even, it had been scheduled, but it had been rescheduled because we had extensions to everything. So it's like, there's not going to be a witness list yet. However, they probably have part of the witness list. And so you need to know. Again, you may want to depose these witnesses. You may want to get statements out of them. Number 16, state whether you contend that defendant statements were made with actual malice. This is the fifth element of defamation when a public figure is involved. Like when you're talking about a public figure, you have to act with actual malice, which is knowledge of the falsity or reckless disregard for the truthfulness of the matter. You have to prove that they did it with actual malice. And that's a tough thing to do if you're found to be a public figure. We had our first ruling on the anti-slap, the judge called both of us public figures, but it wasn't necessarily in the findings. So it's kind of confusing as to whether or not the court would have considered either or both of us public figures. I mean, I think in regards to this matter, we probably both were, and that would have been the right answer. But hey, I don't know. That, of course, is an advantageous answer for me. I'm biased towards that answer. So take that for what you mean it for, or whatever. Number 17, identify all individuals, entities, or organizations, you believe saw, heard, or were otherwise exposed to the allegedly defamatory statements made by defendants, and describe how you became aware of their exposure to the statements. Interesting question. And then number 18, describe in detail all communications you had with defendant Nicholas Rekieta or any representative of Rekieta Law LLC from January 1st, 2020 to the present, including but not limited to emails, text messages, social media messages, phone calls, or in-person conversations, and provide the dates, times, and contents of each communication. So this one would be really hard just because that, like, and I don't mean this in any negative way. This one would be practically difficult for anybody in the same shoes as Monty, because some of the conversations or communications that he had with me were made in a Rumble chat. Well, the Rumble chat isn't preserved, but he alleges in his lawsuit that he made comments on Rumble, and I responded on the show on Rumble, on my channel and on Megan Fox's channel or whatever. And so they happened. So what were the contents of them? Like, that would be just a difficult one to answer because it's hard to get access to that data. Rumble doesn't preserve the chats. So there we go. Those are the interrogatories. Those are the questions we asked. And again, cannot speculate on what the answers would be or the reasoning behind not answering. But once we sent that document over in particular, that was the withdrawal occurred very, very quickly after that. So, Montegraph has cited a lack of funds, and that could absolutely be because, though this case is about to get expensive in response to this, but I don't know exactly what his internal reaction was. So it's, that's that. People are able to draw their own conclusions from that. It's not up to me to guide that or speculate on it. I don't really care. I mean, I have my own personal thoughts as to why he withdrew, why he didn't answer the questions, etc. But they don't matter because the case is over. It's done. One of the problems, not problems, I guess one of the boons for me is that, he had sued me over this, but the statute of limitations clock still goes, A voluntary dismissal or withdrawal is typically done without prejudice unless it's specifically stipulated to that it's with prejudice. Mine is not with prejudice. However, all of the statements were made over 2 years ago. So now bringing trying to bring suit again on the same statements would run into statute of limitations questions and problems with it. So you don't get to just file lawsuits and then quit, and then file lawsuits and quit and extend the statute of limitations out forever. The courts don't want people doing that and kind of abusively making people sit under this pressure of a civil lawsuit for years and years and years. They really don't want that to happen because it's really stressful on people, and it's expensive and it's time consuming.